Dear Mr. Smith, dear ladies and gentlemen, dear colleagues, I must share with you first what I'm going to do this evening. I will ring both my children and tell them that I was opening the conference where there was a word technology. Because when always I appeared somewhere near something which had buttons, my children always told me, don't touch anything. And I think this will be an interesting discussion about personal development. Anyway, I am very delighted to join you for your discussion on advancing technology and preserving fundamental rights. Advancing technology and preserving fundamental rights, that is exactly what we want to achieve with Europeans' digital single market strategy. And they are two sides of the same coin. We need to protect the fundamental rights of our citizens and, at the same time, to create the right framework for business to fully benefit from the opportunities the digital single market offers. This will be delivered by our data protection reform. I am proud that we finalized the agreement with the co-legislators on this important piece of legislation before Christmas last year. We will now prepare the formal adoption and the implementation. It is high time that we delivered. Our citizens rightly expect us to keep them safe and to protect their freedoms. And our businesses expect us to set unified and future-proof rules that set the right signals for innovation in the digital economy and that lower their burden. All this is important to secure trust in the Internet, a challenge that we face on both sides of the Atlantic. Following the important step we take in Europe with the adoption of the data protection reform, we count on the US to continue their path to strengthen privacy protections, including for Europeans. And this will be crucial in order to restore trust and legal certainty for transatlantic data flows. In Europe, we have finalized a robust set of rules to make sure people's rights to personal data protection remain effective in the digital age and at the same time benefit the development of the digital economy. The reform strengthens citizens' fundamental rights in the digital age and facilitates business by simplifying rules for companies. Data protection by design and by default will become an essential principle. It will incentivize businesses to develop new ideas, methods, and technologies for the security and protection of personal data. The new regulation promotes techniques such as anonymization, removing personally identifiable information where it is not needed, pseudonymization, replacing personally identifiable material with artificial identifiers, and encryption, encoding messages so only those authorized can read it, to protect personal data. This will encourage the use of big data analytics, which can be done using anonymized and pseudonymized data. The new rules will apply within 2 years after formal adoption. This means early 2018. We need to use this time well to get everybody, it means member states, data protection authorities, citizens and companies to prepare for the new rules. The Commission will work closely with the member states, data protection authorities and other stakeholders to ensure a uniform application of these new rules. And we will also run awareness-raising campaigns so that citizens know their new rights. Regarding transatlantic data flows, we have finalized the negotiations on the umbrella agreement on data protection requirements for exchange between law enforcement authorities between Europe and the United States. And we are now in a crucial moment in our negotiations on a successor arrangement for data transfers between companies. The European Court of Justice ruling in the so-called Schrems case has given a new sense of urgency to these discussions by annulling the old safe harbor arrangement. Only a comprehensive arrangement with clear legal commitments can ensure the level of data protection Europeans are entitled to under EU law. And this is what the judgment requires. Where personal data travels, the protection has to travel with it in a system that is equivalent. We have worked intensely over the last weeks to address the remaining open issues, such as access by public authorities, redress possibilities for EU citizens, monitoring and enforcement. This week, the discussions will continue and meetings will be held at various levels, including in the margins of Davos. And I rely on you, Mr. Smith. Also, there are my colleagues coming and they will have negotiations and perhaps also informal meetings with our American partners to push a little bit forward the discussions. On surveillance and national security, we need guarantees from the US that necessity and proportionality principles will be applied when companies request data. We are also asking for more transparency on limits to security services collecting and processing data. And we need guarantees that there is effective judicial control of public authorities' access to data for national security, law enforcement and public interest purposes. And last but not least, we need US Congress to adopt the Judicial Redress Act in order for EU citizens to enjoy the rights US citizens already enjoy under the 1974 Privacy Act. This is a precondition for the conclusion of the Umbrella Agreement. Businesses are supportive of these steps because they are eager to restore trust in transatlantic data flows and in the Internet. I count on your continued support to help us find a solution for a new arrangement that respects the ruling and that enhancing transatlantic data flows, which are so important for our communities and economies. I remain convinced that it can be done. On that note, I will switch to listening mode and hear what Brad Smith has to say, and I wish you all very fruitful discussion. Thank you very much.